Did you know that many plaintiffs are going to face higher taxes on lawsuit settlements under the recently passed tax reform law? Some of your clients are going to be taxed on their gross recoveries with no deduction for attorney fees, even if their lawyer takes 40% off the top. So in a $100,000 case, that means paying tax on the $100,000, even if $40,000 goes to you, the lawyer. Hi, I'm Mark Wallstrom. I'm back again with another segment of my trial lawyer tutorial series. Now, I want to be clear right out of the gate that the new law should not impact qualified personal or physical injury cases. Those stay totally tax-free. It also should not impact most plaintiffs who bring claims against their employers. Those cases still allow an above-the-line deduction for legal fees, although there are new wrinkles in sexual harassment cases, which is the Harvey Weinstein tax I've discussed in prior videos. However, for most other types of claims, unless the suit is related to the plaintiff's trade or business, there may be no write-off for legal fees or costs. And that means your clients are going to be taxed on 100% of the recovery, and boy, is that going to be a tough conversation between the lawyer and the client. Now, the list of settlements and cases facing tax on 100% is endless, but some of the examples are suits against investment advisors for bad advice, website suits for invasion of privacy or defamation, claims related to divorce litigation, that's a big one, wrongful imprisonment and arrest. Now, you may have heard about the case just this week of a guy who was locked up for 31 years and got a $1 million settlement from the state of North Carolina. Imagine his shock when he finds out it's fully taxable and he can't deduct the legal fees. Hopefully this was done pro bono for this poor guy, or he's really stuck. Now, other cases that are swept in under this would include the intentional infliction of emotional distress. That's a big one. Insurance company bad faith. A lot of those claims are out there. One of our favorites, legal malpractice, no longer deductible. Punitive damages. Like I said, the list is endless. Now, Congress, after some screaming by trial lawyers, subsequently enacted an above-the-line deduction for legal fees in employment claims, and also certain whistleblower cases. And the tax law on those cases have not changed under this new tax bill. The award in those cases is still fully taxable, but at least the legal fees continue to be deductible. So you see, the big change is that up until now, even if you did not qualify to deduct your legal fees above the line, you could deduct them below the line. Under the new bill, now there is no below-the-line deduction for legal fees. And IRS Form 1099 regulations generally require defendants to issue a Form 1099 to the plaintiff for the full settlement, even if part of the money is paid to the plaintiff's lawyer. So there's no escaping this. What this all means is that you must get tax advice early on these types of cases, before the case settles and the settlement agreement is signed. And you've got to communicate this to your client. For many, no tax deduction for legal fees is going to come as a real shock, but it's even more shocking if they only learn about it after the settlement plan. Plaintiffs who have advance warning and advice can at least engage in some of the tactics allowed under the law to minimize the impact, but they have to make those plans up front. Now, one solution is going to be structuring legal fees to minimize the year one tax hit, as well as structuring the client's award over time as well. I've successfully done that in some very significant litigation in the past, so there are ways to mitigate but not avoid the tax hit in a way that satisfies the client. Also, I've recently found the use of qualified settlement funds can also allow for a more rational planning strategy, and I can discuss that with you on a case-by-case basis, if that makes sense. The key is awareness and advanced settlement planning. Hey, I hate to be the one to bring bad news, but you need to be aware, informed, and plan in advance with clients on this type of litigation. I'm going to be back again next week with another update on issues in settlement planning that trial lawyers need to be aware of. Until then, I'm Mark Wallstrom, and thanks for watching.